So thank you everyone for joining our March Lunch and Learn webinar featuring Erika Riggs of Disability Law Group. She's a highly respected attorney specializing in Social Security disability and veteran disability claims. She has earned many accolades, including the State Bar of Michigan's Champion of Justice Award. She's also been recognized nationally with the American Bar Association on the Rise Top 40 Young Lawyer Award. And we're very excited to have her with us today. And also with us, you probably know Michele Fuller. She's the owner of Michigan Law Center and president of Advocacy Inc., which is a nonprofit organization that administers special needs and settlement trusts. She's been practicing special needs planning for 25 years, and she is the 2018 recipient of the Unsung Hero Award given by the State Bar of Michigan.
Thank you so much for being here, Erika. And I know that this is very common questions that we're looking at. So I practice special needs planning and settlement planning. And so inevitably, when I'm talking with someone who doesn't have Social Security benefits yet, or is in process, or is having difficulty, Erika's firm, Disability Law Group, is my go-to referral source. And so that's where I point my people to, and with great success. And so thank you for joining us, Erika.
Of course, I'm so honored to be here. Thank you for thinking of me. These are really important topics and I'm sure questions that we'll be discussing. And it's always an honor to collaborate with you, Michele. You are just a powerhouse in your area of law. And I love dealing with you and your team for any referrals I have regarding estate planning, special needs trust, and really the nuances and expertise that you have speaks volumes. So thank you again for having me.
Well, thank you. Thank you. So I think let's start with the basics, Erika, which is, what is the difference? What is Social Security disability? Because when I ask people, what do you have? What kind of benefits are you on? They say disability. They don't necessarily know how they qualify or what it means to qualify. So maybe we can just start there.
Yes, that's great foundation. And there are a number of disability programs offered through Social Security. The most common one that we hear of, as you mentioned, SSD, Social Security Disability, also referred to a couple different ways, SSDI, Social Security Disability Insurance, and Disability Insurance Benefits, or DIB. So these are terms for referring to one of the disability programs, and it's really under the umbrella, without getting too much into the weeds here, of Title II claims. There are a few different claims that fall within that as well. Just to briefly mention, is important for people to know about is disabled widows benefits, disabled adult child benefits. These are separate benefits available for people who may qualify under the technical and medical criteria, which we'll get into, all under the umbrella of that SSDI or the Title II program. The other one that's very common, and I think we'll probably focus much of this today on, is SSI, Supplemental Security Income. So let me just talk a little bit about the two main programs here, SSD and SSI, and what the differentiators are that people should know about. So for SSDI, this is a program for individuals who have worked long enough and recently enough and paid in sufficiently to Social Security. So through your payroll taxes, through those FICA tax dollars that you see if you're working, coming out of your, if you look at your pay stub. So your qualification for this program very much depends on your work history. You have to have earned enough work credits, and this is really what's called the technical criteria for this program. The other program I mentioned, SSI, this is more of a needs-based program. So this is for individuals, it could be adult or a child, with limited income, limited resources and assets. And that's really the main difference or marker of this program. So regardless of your work history, an individual may be eligible for SSI. It's designed for disabled individuals who may not have sufficient work history to qualify for SSDI, and they can demonstrate financial need and financial assistance that they require. So kind of to recap here, both programs have the same medical criteria for proving disability, but the technical criteria very much differs depending on the programs.
Okay. What do you think some of the biggest misconceptions are that people have about Social Security disability?
How much time do we have, Michele?
as much time as you need, Erika. This is a
Okay.
great, I run into this all the time, and I know how I answer this for people, but I'm really curious to see what your response is.
Okay, so there are a number of topics within this question that kind of come to mind. But a big one is that, I have a doctor, they say I'm disabled, so I should automatically be approved. And I'm going to kind of take the flip side of this next, but
Mhm.
it's important to note that a doctor's statement is very helpful and can really be a very important piece of this claim. But Social Security really requires objective medical evidence, and they have a strict definition of disability, but it's one that it can be attainable. So really, Social Security, it's important for you to know that Social Security is going to look at the big picture. They're going to look at everything. On the flip side of this, we hear sometimes that, well, I don't want to file for disability because I don't have a doctor who is going to fill out a note. I don't have a doctor's letter saying I'm disabled. So, I don't qualify. And that's not the case either. A specific letter or note from your doctor is not required for the disability process. I know there's a lot of things we do here at my firm at Disability Law Group to try to help obtain those reports and those letters throughout the journey of a claim. But you don't need one. And if you have one, it doesn't mean that you'll be approved. Another big one is about work. This comes up all the time. And,
Yeah.
people feel that they can't work at all, while they're going through the disability process. And that's not necessarily true. Social Security does have some rules in place to evaluate a person's work if they are working. And those rules very much differ if you are applying or going through the disability process, or if you have already been approved. So it's important to know that Social Security does allow, or it doesn't preclude you from qualifying for disability if you're working. It very much does matter, though, how much you're making. So we'll make sure to talk about that at some point today. And another one, too, is that if I get denied one time, I'm never going to be approved. Or that, I have to apply 3 times before getting approved for disability. These are very common myths. I can't tell you how often I hear these statements and these myths from people. And it's important to know that, yes, Social Security does deny a vast percentage, over 60% of disability claims. And we're certainly monitoring that as time goes on. And that may change, but don't let that deter you from filing or from going through the appeal process. Because if you don't appeal your disability claim, you could be losing out on benefits that are rightfully yours if you go and reapply later. So just know that those are all some common myths that I hear.
I think that you said something interesting, which is a doctor's letter. A doctor cannot, is my understanding, is a doctor cannot determine disability. That is the sole, that's the purpose of the evaluation that Social Security does. A doctor issues a diagnosis. But what I see, and I don't know maybe what your thoughts are on this, but what I see is that there's, first, let's talk about the definition of disability and what's required. And often we'll talk about this where someone can have disabilities, in other words, physical or mental challenges, but you aren't considered disabled by Social Security unless it inhibits your ability to work to a certain level, enough to support yourself. And that threshold for Social Security is very low. So you and I are attorneys. If I had a problem with my left foot, could I still practice law? Yes. So there's a difference between having disabilities and being disabled for Social Security purposes as an adult. So can you talk about that a little bit? Like what kind of proofs, or like really what's the definition of disability for Social Security? What does that really mean?
Yeah, great points. And what you initially led with was about the disability finding and it really being a vocational finding. And that's very true. It is a vocational finding that is reserved to the commissioner, is reserved to Social Security, and for adult disability cases and for child's cases too. Social Security is going to look at those certain domains and the limitations that a child might have for their disability case. But in order to prove disability, you have to show that you have a medical condition So by nature of that, it could be just one condition, or more commonly, a combination of impairments that is expected to last, or maybe has already lasted for 12 months or more, or the potential to result in death, meaning you have a condition or a combination of conditions that are so severe that it is terminal. The doctors deem it to be terminal. So that is the definition for Social Security's criteria. You also have to be unable to work. Of course, there's a series of criteria Social Security is going to look at for adult disability claimants, and a big part of that is work at a certain level. So we talked about, you can potentially work while you're filing a claim, going through the process, or even receiving disability, but it very much depends on if you're doing this full time. You can't be working full time and alleging disability, absent some very strict exception while you're going through the claim or on a trial work period. But essentially, what you should know is that Social Security is looking at SGA, substantial gainful activity. This is the big qualifier if you're working and you're going through the disability claim process. And for 2025, that amount or that limit of earnings that you're allowed to have is $1,620. And this is monthly gross income. So not your net or your take home, but your gross monthly income. And $2,700 for blind individuals going through the disability process. So those are the main things Social Security looks at. There's also listings or the Blue Book definition of disability if you have a condition that is one of those that might be on the criteria to qualify for disability by nature of it being identified as so severe that you should be approved at that level. And then, of course, they're going to look at your work history for an adult and determine if you can perform your past work or other work that might exist.
Are there certain conditions that are harder to get approvals for?
Yeah, that's a great question. And sadly, I would say that mental health conditions are one that notoriously is difficult to prove if you do not have treatment. There's a lot of barriers to mental health treatment. There's a lot of stigma surrounding mental health in general and the treatment for these conditions. And also Social Security makes it, the regulations, the way that they are inherently make it difficult for someone under the age of 50 to be approved for disability benefits. So I would say if you're under the age of 50 or at any point in time, if you strictly have mental health impairments, while it may be more difficult depending on the facts of your case, depending on your treatment history and the symptoms you're experiencing, it is not impossible. And we prove those disability cases all the time, but that is definitely one that is probably more common.
I think so too. I would agree with you. Anything that's, I would say, I call them invisible disabilities, right? Mental health, autism, severe ADHD, things that impair people's function to be able to work, follow directions, sometimes autoimmune diseases, things like that are generally, you look at somebody and they look typical. They look like everybody else until they have to start doing stuff and they just can't.
Do you have to apply for SSI first and be denied before seeking out an attorney?
That's a great question.
Mm-hmm.
The answer, at least from my point of view, from my law firm, is no. Now, there are potentially some law firms out there that will only help people if they've been denied, but we are not one of them. We actually do specialize in cases for disability benefits from the application level. So maybe you need help with applying for disability. It could be SSI or SSD or both potentially. And we help all throughout the appeal process if needed through the United States District Court level in Michigan.
That is a great question. So what I see, I want to jump a little bit to kind of what you just talked about. Like somebody gets denied or they initiate the process and then they'll get their first denial. You talked about like sometimes people apply 3 separate times. And what I find is that when people don't have an attorney, they are really at a disadvantage, especially if it's not something that's on the compassionate condition list. Like you said, something that's just a kind of a no-brainer. Their condition is so severe that they're on this special list that you get automatic coverage or automatic benefits. And so what should people do if they do get that denial or they're in the middle of something going, gosh, this isn't going very well, or I'm really concerned that that this isn't going to happen, what do they do?
Yeah, if, of course, I would recommend seeking an attorney, one who specializes, as I do, in disability benefits, because there's a lot of nuances. The laws change all the time. The commissioner's changing all the time. There's a lot of different ways to help prove disability. There's a lot of best practices and strategies that you can employ. And so seeking advice from an attorney who's experienced and specializes is definitely important. But other things you can do is just making sure that you're seeing your doctors, making sure you're communicating with Social Security if you don't have an attorney, because there will be a case examiner through a branch of disability associated with Social Security that will be reviewing the case and possibly sending people for exams, obtaining records. And a big problem tends to be that people forget to or can't get a hold of their examiner. So thankfully, we do have an electronic sort of portal with Social Security to be able to update our clients' files. So if somebody calls us and says, I'm seeing a new doctor, or I just had a procedure done, maybe I'm going to be starting physical therapy, whatever it might be, we want to know about that right away, because while the process can take some time, we certainly don't want to cause any delays. We want to make sure we're doing our part, doing everything we can to have these cases move forward, not only as quickly as possible, but with the best result possible, to kind of, minimize the chance of you being denied from the initial application level. And so those tips are very helpful. Getting in your records, making sure that Social Security knows about all of your treatment, the full picture of what's going on with you, so that they can hopefully make the best decision as quickly as possible.
I find that the communication from Social Security, those letters that you get, they're not very straightforward, or sometimes you'll get a letter and it asks for more information, and you get it, and the deadline is after you received it, or it already occurred and you just received the letter. But I think that if their claim is denied in general, or they get some communication, is it better to start? So I get this question a lot. Is it better to start a new process, or is it better to appeal?
So it sort of depends on the case. We definitely want to make sure we're looking at everything. If you do get a decision, because there's a lot of reasons someone might be denied, and a common one might be a lack of medical evidence. So Social Security may or may not send you a letter that says, we try to get these records, or we try to reach you, we try to contact you so that we can determine if this is the right facility, or if you're being treated anywhere else, and they couldn't get a hold of you and they had to move forward with the case. Sometimes it's that, failure to cooperate letters from Social Security. So, we want to make sure that we're cooperating. We want to make sure we're doing the best we can to get a hold of them. There are certain instances where there will be those barriers, playing phone tag with your case examiner. So that's why it's really important to get those into Social Security immediately. But if you do get a decision that has appeal rights, I would almost always recommend that you appeal, unless there's some reason why you wouldn't qualify by the time you get that letter. I would always recommend that you appeal and make sure you're very aware of what your appeal time frame is, which is generally 60 days plus 5 days mailing to submit your appeal. And if you are denied at the initial application level, the next stage currently in Michigan is the request for reconsideration stage. So it's an appeal called a request for reconsideration, and that can be done online on ssa.gov. That is something we do as well for our clients. So that is something that I would recommend doing right away. You don't want to keep filing, and there may not be an opportunity to reopen your prior case if you refile, depending on when you do that and what evidence you have.
It seems like the disadvantages for refiling is that if you are successful on appeal, when does your benefit begin? Like, when does that benefit start accruing versus refiling?
Yeah, and that's a great question too, because a lot of people get stuck on the fact that, with SSI payments, your benefit can start when you file, right? Or when you protectively file. So we want to look at those dates too. Sometimes you call to set an appointment because maybe the website's down. That's happened more often in the last year than I've seen in over a decade. So if the website's down and you can't, start your application or get a hold of anybody, that's a problem. The wait times can be hours, sometimes just to get disconnected or not have someone at Social Security appropriately handle your question or your issue. So it's important that you're pushing forward, you're advocating for yourself, and you're aware of, what your rights are. So when we talk about, filing your claim, SSI is going to look at that date to determine when your benefits should be effective, unless they determine you're disabled at a later date, which is potentially something you can also challenge on appeal. With SSDI, the work credit program, you could potentially go back a little bit further. It would be 17 months prior to when you filed your application, minus the what we call, or what Social Security terms, the 5-month skip, or the 5 months where they effectively hold the claimant's benefits. And then so therefore it ends up being approximately 1 year prior to when you filed your claim, depending on the case. You have to prove disability began that far back. So we're looking at always all of these things to determine what's the best, effective date or onset date for a disability claim, what Social Security missed something along the way and we need to appeal something. More often than not, we're getting some decisions from Social Security which are partially favorable, meaning Social Security finds the person to be disabled, but doesn't, pick an onset date as far back as the claimant, or that we believe the claimant first became disabled. And so we have to review that and discuss that with the client to determine if we should appeal and what the best course of action will be to make sure that they're continuing to get their benefits if they are waiting an appeal.
Because I think that back pay is a big deal, and to miss out on that. So if you keep, so I think that, like, the bottom line is that basically if you get if you've tried this yourself and you've gotten a maybe less than favorable decision, then you need to call an attorney because you're probably going to have a different result. And rather than starting a new application, make sure you call a disability law group right away, because you have 60 days really from the time that you've received it, and potentially more if there's good cause shown, which is, you don't want to trigger that if you don't have to, but sometime within that 60 days, you don't want to wait until day 55 to call an attorney. If you get that denial, you've got to call right away, because there's a lot more that you can do. And you think, oh, I'll just apply again. But if you've waited a year to go through this process just to get a denial, you might be giving up a year of back pay.
Yeah.
Do you think that's accurate? Did I say that correctly?
Absolutely. Yes.
Okay.
And when some people file their appeal late and then come to us, and then Social Security or a judge has to make a decision about good cause. And it's a very narrow situation where they might grant that. If they don't, they're not, Social Security or the judge won't even go on to evaluate the severity of the medical conditions. They'll send it all the way back. So it's important that, you're mindful of those appeal deadlines. And something that we like to do as well is, in addition to making sure we're being mindful of the dates and putting the best claim forward, is coming up with the best strategy unique to that person, and so that might mean those letters or statements to a doctor that really details the limitations they have. So it could be, you have a physical, neurological condition. We drafted forms recently regarding clients who have lupus, rheumatoid arthritis. Sometimes the listings regarding the severity and what's required to show that change with Social Security's rulings and the regulations. So staying up to date on that is really important, so that we can edit any forms needed for our clients' doctors and specialists to review to kind of help their case, to present the best case. And also what we like to do is send our clients calendars, like diary, to not only document their medical providers and any changes, but really what their symptoms are, because, we're not seeing our doctors every day, right? But our clients, they're suffering generally almost, daily. And I want to know what kind of symptoms they're experiencing, not only when they're at their doctors. That's very important for them to be open and honest with their doctors. And just really kind of make the most of those visits, talking to your doctors about the symptoms you have. Maybe you go into the doctor and you're kind of feeling a little bit better that day, right? And so our clients, may sometimes say, I'm doing okay today. I'm here for a medication refill, but they forget to talk about what last week looked like or what yesterday looked like. And so it's really important to kind of keep a record, keep that top of mind, maybe bring someone with you that you feel comfortable with, who knows you well, just to make sure you're reporting everything and that your doctor knows what's going on. And then the diary and the log that we have is an opportunity for our clients to really tell a little bit more of their story. Because at the end of the day, Social Security, they need to look at everything. And so we'll present that, we'll submit that to Social Security as well.
They tend to, for whatever reason, be really optimistic when they go to the doctor's office. And if you're ever in doubt, bring your partner with you, right? Because they will tell the doctor the straight, well, remember the headache that you're having every day and that you have to take medication every day to manage? I used to be able to mow the lawn or rake the leaves, and now you can't do any of those things. They'll remind that person that, oh, you used to be able to do these things and now you're in chronic pain. So, Maddie, it sounds like we have another question.
My 6-year-old receives SSDI and has been on it for over 6 months. I want to place his SSDI into a disability trust, which would then be held within another trust. Since his payments go directly to me, does Social Security require the managing trust to be a third-party trust now and would need to be converted into a first-party trust when he turns 18?
For that one to you, Michelle. That sounds like
Yeah, that's
Yeah.
it. So that's a very nuanced, a complex question. So first, you cannot direct Social Security funds into a trust. They must be handled by the person representative who's been appointed by Social Security to manage those funds and report to Social Security about how they're using those funds. If those funds accumulate to the point where you're not using them, we should talk about that because you should be using those funds to support that individual. It's what they're for. But if you do accumulate, especially like SSI, or if you have a resource limit, so that's associated with medical benefits, like SSI has a $2,000 asset limit. If you're exceeding that, you can put funds into an ABLE account. You can put funds into a first-party pooled special needs trust, but you can't commingle first-party money with third-party money, meaning money that belongs to the individual is called first-party money. Money that belongs to someone or was generated from someone else, whether it's fundraising, grandma and grandpa are generous, anybody else that wants to give money to that person with disabilities is considered third-party money. You cannot commingle those. And so that the person asking the question is kind of confusing those layers, and there should be a firewall between first party money and third party money. So if you have additional questions, you can email me directly, Michele at milaw.center, and I'm happy to answer your question.
I filed for my son who has schizophrenia and was turned down. I plan to appeal, but if my appeal still results in denial, can I then hire an attorney and pursue a second appeal with an attorney?
great question, and it really highlights the importance of all the things we've been talking about, right? Mental health, and I want to underscore here the importance again of mental health treatment. It sounds like there's a denial letter, and so we want to make sure that you file your appeal right away and keep record of everything. So if you file that appeal, let's say it was an initial application that you filed that was denied by Social Security, on your denial letter, if you take a look at that, it should tell you, even if it's sort of basic, reasoning about why, it doesn't give you a whole lot of detail. It should tell you if they're denying based on they believe the person's condition is not severe enough under the rules. That is an appealable decision, and I would recommend appealing that. Make sure you are within your time frame for the appeal. Usually in the last few pages, it will tell you, you have 60 days plus 5 days mailing to submit your appeal, which again, that would be called your request for reconsideration. You can absolutely do that yourself, even though I don't advise to do it that way for a number of reasons, some of which we've covered today. I want to make sure that we're putting this case in the best position possible to be approved and not have to wait and continue fighting appeal after appeal. But also, you mentioned what kinds of things you could do before hiring an attorney. And if you'd like to handle this on your own, I would recommend that you communicate with Social Security regularly, know who the case examiner is, that they should give you an extension, reach them and call them with any updates. And of course, this could be if your address changes, phone number, anything like that. But definitely if your doctors change, a mental health specialist, make sure that this person is seeing, as many professionals as possible to treat the condition. And, this is important not just because of the case, right? Because it's very much important for the case to have as much medical records as possible. I would advise, mental health specialist therapy and maybe a psychiatrist or psychologist if that's something that's not being done. Sometimes our clients get 2 or 3 opinions before they find someone that they really feel comfortable with and that they trust. But the more, medical evidence, the more records to support this consistently, the better. But it's also important for their own health, right? To be seeing the proper providers who can treat them and really make them feel better. So make sure that you're seeing the specialist. If you have questions, even if you're not ready to yet hire an attorney, you can always give us a call. We'll have our information shared. You can look us up, disabilitylawgroup.com.
I'll just chime in a little bit, which is a lot of people will say, well, I've got this diagnosis, and this diagnosis is pretty severe, and it's evidenced by a number of hospitalizations. And I have to say that Social Security really doesn't care much about the diagnosis if it's not on the compassionate condition list. In other words, like a renal failure, stage 4 cancer, that kind of thing. And particularly mental health issues, including autism, schizophrenia, bipolar disorder, depression. Social Security tends to care about how the impairment or how the challenges, how the mental health or physical challenges impair your ability to work. And so this is what I consistently see is missing from a medical functional analysis. And you mentioned that word function, Erika, early on in our discussion. And if there is no tie in there, just a medical diagnosis, even though you see, frequent hospitalizations, I think 5 hospitalizations in the past 6 years is pretty frequent. That's a condition that isn't stabilized.
Yes.
And somebody's struggling. The family is struggling. So should they be considered disabled? Yes. But then how do you go about proving that? And it takes, I think, those reports that analyze the functional impact of this person's condition on their ability to work. And that seems to be what I think a parent or advocates have to push for. What are your thoughts on that?
Absolutely. And immediately I'm jumping ahead to listing that you talked about. You do not have to meet a listing to be eligible for disability, but it's important to know they exist. And for your question in particular, this breaks my heart because 5 hospitalizations, that is telling me that, something is not working. Something, whether it's the medication, the treatment, this person needs more help. And I applaud you for attending this webinar and for being brave to ask that question, and for everything you're doing to make sure that they're getting the help they need, whether that be emergency room level care, inpatient, psychiatric treatment, mental health therapy, whatever you're doing. I just applaud you for that. And I will say though, to kind of answer your question on how putting this person in the best position possible, looking at the listing. It's 12.03. You can actually Google Social Security or SSA Blue Book listing 12.03, and some of the criteria will come up, and maybe that they have these conditions, these symptoms associated with the condition. So Social Security is looking at whether the person has delusions or hallucinations, disorganized thinking, disorganized behavior, and how they're interacting with others maybe or responding, and that as a result of those symptoms or symptoms like those, that they have an extreme limitation in one of the 4 categories or a marked limitation in at least 2 of the 4 categories that you'll find if you search that. And so the forms that we've drafted are catered to that, but also the many other limitations that might happen with someone with a schizophrenia, schizoaffective, or any other kind of mental health disorder. So familiarize yourself with that. Maybe the mental health therapist or doctor professional will provide a statement, putting it all together, confirming that this person does have those symptoms and is limited in that way, markedly or extremely, and that may help you get the approval that this person deserves.
Erika, do you find that the state of Michigan can do their own disability determination under BEM 260, which is Bridges Eligibility Manual? That's our state Medicaid policy. Do you find that would be a quicker process? And perhaps if the state and federal does not have to follow a state ruling, but do you find that might help, or have you ever used that as a method to maybe speed up the process at the federal level?
Yes, absolutely. Well, you exactly hit the point here is that Social Security as a federal program does not have to follow not only state determinations of disability, right? And that could be under BEM, that could be short-term or long-term disability, could even be other federal programs. So think about the VA. If you have a veteran and they have a finding of TDIU, total disability, individual unemployability, or maybe they're 100% permanent and totally disabled, that does not mean that Social Security must follow those decisions. But you know what? It doesn't hurt. So I would say get as much evidence as you possibly can within your ability to show that you are unable to work in the case of an adult or you have significant limitations. And that is part of that. That would help. And the more that you have and submit, I think the better and the stronger the case.
Yeah, it's just great evidence that a state agency has done a determination. So let's talk about that actually. So we know Social Security means that once you get that benefit award, that means that you get an income. And it can be based on different things, right? Social Security disability is based on your wage contributions. SSI is just based on the federal benefit limit or federal benefit. And so, but let's talk about the medical part of that and what those benefits are tied to.
Yeah, great question. So Social Security disability, the work credit program, Medicare accompanies that benefit, which is wonderful because it allows people to not only have the monthly income, the monthly benefit from disability, and potentially the retroactive pay as well, which you would be eligible to receive in a lump sum from Social Security if you're eligible for that. But also you have the Medicare to help you as well with coverage, which may be an additional benefit that you wouldn't have had otherwise unless you are entitled to your full retirement, right? We often hear Medicare associated with someone being on earlier full retirement benefits. So that's important for you to know. For SSI, Supplemental Security Income, you're able to receive up to $967 or $1,450 per month for an eligible couple receiving benefits. And the important insurance component to that for SSI recipients is you are also eligible for Medicaid. So this is hugely important for so many people that are relying on SSI to help pay their bills. And, this is their source of income, which is, I put those numbers out there and it's below poverty threshold. It's, and I hate that about the program, but it's important for you to know what could you be eligible for? What benefits are available? What insurance is available? So that's really the two different programs.
And so when I ask if someone is on government benefits and they say I'm on disability, sometimes they don't know what type of benefit they're receiving because someone else is helping them with the application process. And so we have to do a little detective work. And so the first thing we ask is, when do you receive your income? So SSI is paid on the first of the month. SSD is paid on the third of the month. So what's fun though is that can someone get SSD and SSI, Medicare and Medicaid all at the same time?
Yes, and it's so important that we screen for this right away because we don't want to leave any benefits on the table, any monetary benefits or the potential likelihood that you'll be eligible, as in this example, for both SSD and SSI, meaning that you could potentially be eligible as well for both Medicaid and Medicare. So that's really, really important. And a perfect example of this might be someone who would qualify for SSD, perhaps if they were a waitress or a server or someone who might show a lower income, but still consistent, steady income. Perhaps they rely on tips or other benefits, and that's their amount that they're reporting. So for example, for this individual, for their reported income, they are eligible for SSD, but their amount might not be as high as someone who would exceed the SSI threshold. In that situation, this individual may also be eligible for SSI if they are no longer working. They might be eligible for both programs. So if their SSD benefit amount, their monthly amount that they're eligible for through SSD is lower than the SSI limit, the $967 I mentioned for SSI recipients, they could potentially get both benefits and both insurance programs.
Great. My 19-year-old son has a rare genetic disorder. The impact on his work capability is mainly the intellectual disability component. I'm not sure whether he would qualify for SSI. He can work, he has a job at a grocery store, but he'll never go to college or have a job that makes more than minimum wage. Is this a situation that SSI applies to?
It could,
Great question.
absolutely. Yeah, that's a great question. And wow, what a great advocate you are for looking at for looking at all possible avenues for your child's future. I'm immediately thinking about disabled adult child benefits because this person is 19 years old now. And so there are a number of different programs we talked about early on that a person might be eligible for. And so finding a disability for somebody that their disability began before age 22, especially when there is some sort of genetic condition that has persisted before age 22, and we have documentation of that, we want to make sure that we're putting that case forward, that we are applying and appealing if the person is eligible. The big marker, though, that you mentioned, the big differentiator here might be the person's earnings. So we want to make sure that they're not earning SGA level income. So once again, that's $1,620 gross monthly income for a non-blind individual this year for 2025. Generally, that goes up a little bit every year with cost of living adjustment, but that's what it is currently. However, there may be an exception if this individual is earning more than that. If this individual is earning more than SGA, we might be able to show that it is accommodated work, that it is, so any documentation you can get from the employer regarding any special accommodations or
Like special
support and
program?
yes, assistance
Mhm.
that they might need would be very helpful for being able to bring that case forward still.
That Erika, you mentioned the disability determination prior to age 22 and DAC benefits or disabled adult child benefits. This is something that I see routinely missed by families. And so I just want to kind of highlight that when someone is on SSI, right, it's because they can't work and they don't have sufficient work credits, somebody who's usually a young person. And so what happens is they may initially qualify for SSI, but when their parent either becomes disabled themselves, retires, or passes away, they shift to a different program, which is called Disabled Adult Child or CDB, Child Disabled Beneficiary. They call it, Social Security. As soon as you figure out one program, they just call it something new and it's the same program just to confuse you. But the key differentiator here is that instead of looking at the 18-year-old or 20-year-old's work record, they look at the parent's work record. And that child shifts from SSD to being a DAC status. And they get 50%, if the person is alive, they get 50% of whatever that parent's Social Security check is. And then if they pass away or when they pass away, it moves to 75%. And so that benefit is huge. And SSI, you can lose or reduce that benefit very easily depending on work, earnings, gifts. It's I think the most restrictive program under Social Security. Very hard to get, very easy to lose.
Yeah.
Whereas SSD or DAC, that's what we call an entitlement. You've paid into the system, and so it's a form of insurance. So when I'm explaining this to parents and how critical it is for them to get that disability determination, it doesn't necessarily have to be done by age 22, but Erika, how hard is it to get that determination after the fact? If this child has been, let's say, 30 or 40 or even 50 years old, and they've never applied for benefits, what does that look like? Is it still possible?
It may be, it might not be. And there's a number of reasons for that. Medical providers, for example, we talk a lot about how, in the improving disability, this is a medical but also vocational definition and decision that Social Security is going to make. And so they're looking at all of the medical records. So that means that the medical records must be available. And sometimes what they give to patients, like discharge summaries from hospital visits or obtaining records, is not the full picture, is not everything. And as time goes on, as years go on, it's more difficult, if you think about it, for you to remember where you were seen at, what urgent care, what specialists, as the years go on and things change and evolve. So it's really, really important if you are going to file later on, that you are keeping a good record and obtaining all of your records, all of your medical records. Now, if you're working with an attorney, that's something that they should do for you. That's something we do here. But yes, I mean, it cannot be emphasized enough when we talk to people and counsel them all the time about, you may only be technically eligible for SSI now, but I want you to know that this DAC benefit, this disabled adult child or child's disability benefits, is a possibility for you. And I am shocked that, people who even talk to estate planning or other attorneys have not informed them of this, which is why I think it is so critical that any of my clients receiving SSI, anyone I talk to who has a, disabled adult child or a child about to be an adult and they have medical conditions that's likely going to preclude them from working, that I refer them over to Michigan Law Center because they need to know what their rights are, what their options are. If there's a special needs trust, an ABLE account, there are questions we heard earlier about first and third party funding and not commingling. These are really important, benefits and resources available for you that most people and even attorneys don't know exist and don't know the rules about. So it's really, really important you're consulting with experts in the field so that you're doing everything right. And I know I have children too, Michelle. I know you do. It is important that we are, that we know that they're protected, right? And we know
Exactly.
what benefits are available for them. So I cannot emphasize this enough. And that way, if the person does get SSI now, maybe as a child, and even as a young adult, maybe they're not yet eligible for DAC because their parent is still alive, maybe they're still working, right? So they're not on disability or receiving retirement yet. But the unexpected could happen sooner than we plan, sooner than we hope. And if any of those one triggering factors happen, well, now we have an individual, a child who's now a young adult who's been receiving SSI. So they've already established disability. Social Security has already agreed and approved disability under SSI program, can much more easily shift over to the DAC program at that point in time.
Erika, I've always been curious about this, and I know that parents often miss this. Is this something that they have to ask for? Let's say that I'm a parent of a child who's been receiving SSI, and now I'm age 62 or even 65 or 70. I'm now ready to trigger my own retirement benefits through Social Security. Is this something that, and I have to say, oh, wait a second, I have a child with disabilities, you have to switch them over to DAC status? Or is this something that Social Security should be doing automatically? Because I find they typically don't. But
Typically
I want to
don't.
hear what your take is on it.
Yeah, I would agree. They typically don't. They should. It's best practices. They have all the information, right? They're the custodian of they know that the
Yeah.
person and the child's been approved. It's all tied in, but sometimes, they say they need to verify the information, other criteria, like if there's marriage or certain things that might happen at work that might have changed since the person was receiving or first approved for SSI. So I would say it's best practice to make sure that you're documenting everything, that you let them know once a triggering event happens, if you do receive retirement or disability, that you do have a disabled adult child that may be eligible now for that benefit. But another important thing that comes to mind when you mention this is what we do strategically, I think a little different. And it brings me back to a case I had recently with a judge in Lansing. And it was an SSI only case, but my client didn't yet, just like we're talking about, didn't yet have a parent who met one of those three triggering criterias because the parent was still working full time. But the judge says, well, I'm going to approve benefits. The onset date here is going to be the application date. Just to clean up the record, that's as far back as benefits are eligible for a person who receives SSI. Ordinarily, that would be okay. We would have no objection to that. But in this case, I know that I need to prove my client's disabled before age 22 in order for them to be eligible for DAC benefits. This individual might have been in their young 30s. So I said, Your Honor, I understand that, and I would ordinarily agree with you, but I would respectfully request that this claimant has an onset date prior to their 22nd birthday. I gave them the date, the supportive evidence, the exhibits that would, support that onset date. And the judge said, well, why would we do that? Your client's not going to be eligible for any benefits. And I said, I understand, but when the parent does, collect retirement or becomes disabled or God forbid passes away, then this individual will have a much easier time than
Yes.
shifting over to the DAC benefit. And this judge was so happy that we had that discussion, that reminder for him, and had no problem, correcting that and putting the onset date, knowing that it wouldn't affect eligibility for SSI or the benefit amount,
Mhm.
but to set that person up for success down the line.
I think that's a really critical factor here is that, and the value of not, even though you can DIY this, I really, really don't suggest it because I think that you identifying this future issue, setting the client up for success, not just for today, but for a future imperative benefit that I can't stress how often that benefit is missed. And it can make a massive difference to that child that you've been advocating for your whole life. And it's just that simple request that had you not caught it, now they've got a judicial determination of the date of onset, and it is not accurate. Right. And so now fighting that later would be very difficult compared to, you catching it right there on the record and setting that client up for success for their future claim and eligibility for a significant benefit. So congratulations. That's a great lawyering right there. So
could you please talk about Michigan Rehabilitative Services and its ability to determine a disability?
Yes, great question. So much like we talked about a little bit ago regarding other determinations of disability, whether it be from the state level or federal level, there's many different benefits over and above what we've already talked about. That could be MRS, that could be a vocational opinion or assessment that was made maybe through your auto accident case or a workers' compensation case. There are a number of different ways that you can get a finding of disability that you could then present to Social Security. So with MRS records, I find that they can sometimes be very detailed. They can sometimes be very helpful. But you do have a burden now, and your representative, if you have one as well, to inform Social Security of all evidence pertinent to your case, pertinent to your disability claim. And so that does mean you must inform them about treatment, assessment, evaluations from an organization like MRS, so that way they can obtain those records and consider them as part of the disability process.
What is an estimate of attorney fees to help initially file for SSDI on this?
Yeah, that's a great question. We really pride ourselves on making sure that we are, like I said, looking for these cases, moving them along as quickly as possible. And sometimes what that means is there is no attorney fee, because we were able, and our reviews speak to this as well, from our clients. But what this means is we're filing for disability benefits, or we jump in at some point later on, and there is no upfront cost or fee. There is no retainer like you see in other areas of law for Social Security. Social Security is the one who's going to review everything, and they're the ones who set the fee criteria. So in this world with Social Security benefits, it is a contingency fee. So if we do not win the case, we do not get paid, period. If we do win, it would be 25% of any past due benefits, and past due benefits only. Nothing comes out of the future monthly benefit. And there's also a cap that's set by Social Security that sometimes changes, which might intrinsically mean that it will be less than 25%, depending on the total fee award. And then we also pride ourselves on taking on a lot of pro bono work as well. We recently took on cases from the Wayne State University Law School when the professor had sadly passed away unexpectedly. And they have a number of clients who they had agreed to take those cases on pro bono. And primarily those are ones that deal with overpayment issues, cessation cases where the person's disability benefits were stopped, and fighting for those ongoing benefits. And so we did agree to take on those cases, and very proud that we're able to do that, in addition to other pro bono work and initiatives that we do, even though we're not a government funded agency and we are a private law firm. But hopefully that answers your question.
So in other words, no one to retain you or to retain a Social Security disability attorney, no one's writing a check.
If
it's
they
just
do,
a deduction.
illegal. Yes.
Say that again.
If they do, that would be illegal.
Oh,
yeah.
So yes, yeah. So this is something that I run into because my practice is so oriented toward special needs planning and settlement planning. Sometimes people have to defend a trust, or because Social Security can get it wrong where they're evaluating a trust and they say, oh, this is an accountable resource, and it really isn't. And so we have to appeal that decision. So unlike you, my fees are not statutory. There's no back payment to go after. There's no fee. So I have to get my fees approved by Social Security or a court of law, or I could lose my license. And so if you do go see an attorney about a Social Security issue and they have you write a check or pay for them either during the course of the appeal, it's a violation of law and they could actually lose their license. So don't do that ever, basically. No. This discussion has been amazing. And so I think with our last couple of minutes, I really hate to put you on the spot, But I have to ask you, I am getting all kinds of memos and copies. There's all going through the legal community, the special needs community about what's going on at Social Security. And I was wondering if you could talk a little bit about what you're seeing on your end as far as movement, consolidation, and most importantly, how it will affect our ability to advocate for our clients and what people should know who might be watching this webinar.
Great questions. And you did not put me on the spot. I absolutely love talking about best practices and what people can do and how they should really be able to set their claim up for success and know their rights, because that's really what this is about, sharing information and knowing what to expect. There's a lot of unknowns right now, a lot of uncertainty, and we are doing our very best to stay up to date on these changes that seem to be happening by the minute. But I think that it's important to note that there was a couple changes recently or that are going to be coming. And one of them was an SSI rule change that took effect in September. Michelle, I'm sure you know that Social Security will no longer count informal food assistance from friends, family, and community organizations when determining eligibility. This is a long overdue change. So that really reduces the reporting burden and improves, full payment accuracy of payment for claimants who are eligible for SSI. A big one that was just very recently announced that will take effect March 27th of 2025 is regarding overpayments. So this is happening more and more. I get more calls regarding people being cut off or reviewed. And I just recorded a video, it's on our YouTube channel, of tips to when you're going through that or you get that paperwork, because it can be very overwhelming and very scary. So I do have that out there, but Social Security is now shifting to 100% withholding on overpayments for those who are receiving SSDI, so the work credit program. So this means that Social Security will soon automatically withhold your entire monthly check until the overpayment is repaid, which is just terrible. I do want you to know that there seems to be some exceptions to that if you can show significant financial hardship or need. So know that you do have some possibility to change that if that does apply to you. This does not apply to SSI overpayment. So if you are on SSI and you get notice of an overpayment, I want you to know that that should not be withheld at 100%. That should continue to be withheld at 10% or lower, depending on what your situation is. So this is going to affect a lot of beneficiaries automatically. And it's important for you to know your rights. Don't just, if you receive a letter, there are typos, they sometimes make mistakes. So know that there are possible appeal rights, know that there are, law firms like ours that will advocate for you, that can help you, that can guide you. Don't give up. Just know that you are not alone. And if you have any questions about the changes or paperwork you might get or filing, you can always reach out to us and we would be honored to help.
I think by contrast, that is a huge, huge issue. I know that we're going to get flooded with concerns where people are getting 100% of their check. I don't know anybody that wouldn't have a financial hardship if 100% of their income were, it just didn't show up. But I think that you bring up some excellent points about how they can advocate for themselves, that they know that their rights, what their rights are, and how they can advocate for themselves, which is always very powerful to make sure that people understand what they themselves can do. And briefly, can you talk about, like, by contrast, the Social Security Fairness Act and what people can expect if they just have suddenly a bunch of money show up in their account?
Yeah, so if you have questions, like if you get information from Social Security that you believe is not accurate or is not true, you want to make sure that you are, of course, documenting and reporting everything right away. It is very, very important that you are knowing, what to be expected if there's an increase in your payments. There's a lot of fraud that is, happening very unfortunately for many people. And when you talk about people who are, who have disabilities, who are already very vulnerable, and it's already difficult for you to, manage your accounts, know what your rights are, see your doctors. But, you want to make sure that you know what you're entitled to. So if you have any questions about the amount, the accuracy of your amount, the additional money that you may be entitled to, you can always give us a call and we're happy to look into that for you.
Excellent. I cannot thank you enough. I think this was fantastic today. And thank you so much for sharing your expertise, Erika, and demonstrating exactly why we refer all of our cases over to you. So thank you so much. I just really enjoyed this today with you.
Thank you
Yes,
so much,
thank
Michelle,
you.
and your team. You guys have been fantastic to work with as always. Thank you, everyone listening, for your engagement. Your questions were incredible, and we'll hopefully have more of these webinars and collaborate more in the future.
I agree. And
Yes,
thank you,
thank
Maddie.
you. Yep. Thank you everyone for joining. Thank you, Erica. This is the conclusion of our webinar. If you have any other questions, you can reach out to either Michelle or Erica with any other questions you weren't able to get answered. So thank you, everyone. Have a great rest of your day.